Thank you, Doug, and let me express my thanks to you and to Ben Wilfond for inviting me, but not for putting me on today's program in a position parallel to Eva Moses Kaur. What an extraordinary life story she shared with us. I do hope that you all take to heart her message of forgiveness and begin to apply it immediately, such as to my presentation. For all its differences, my talk does have in common at least two things with Eva Kaur's presentation. First, my remarks are not confined to issues of pediatric research, but rather deal more broadly with research with human beings, and then propose the pediatric aspect as an amplifier of the issues that I will broadly identify. Second, I will be inviting you to think again about the roots of the present regime for ethical review of human subjects research. I suppose that much of what I have to say will be familiar to you and may also seem like ancient history. Yesterday, Norm Faust suggested that what has been derived from the historical experiences I will mention is now just symbols whose original meaning has been lost, so that they now serve merely to identify a certain tribal allegiance and are mere shibboleths. I too am concerned that some of our ethical commitments are now honored verbally but not in practice. But I don't share Norm's conclusion that they are nonsense on stilts and cannot be taken seriously. Instead, I will echo Eva Kaur's caution that doctors must, as she said, walk a very narrow line when they move into research. I've already given you some idea of why I gave this talk the title, Young Patients, Age-Old Problems. But now let me delve a little deeper into the age-old problems. I believe we are now entering a time of uncertainty regarding research ethics, in which answers that we've provided in the past to some basic questions are being brought up for re-examination. It was nearly 45 years ago when Jay Katz and I were working together on what became the first casebook in this field, Experimentation with Human Beings, which was published then in 1972, that we composed the following question: when may a society, actively or by acquiescence, expose some of its members to harm in order to seek benefits for them, for others, or for society as a whole? Today, a number of leading bioethicists have suggested that we give a new answer to this question of when. The immediate provocation is an embrace of the drive to improve medical practice by studying its effects on a continuous basis and feeding the findings back into practice immediately. That is, the learning health system that Steve Joffe described yesterday. Further impetus for this re-examination comes from criticism of the approach that OHRP adopted in dealing with support, as Nancy Cass described, as well as broader doubts about the worth of IRB review, generally and more fundamentally about the importance of informed consent. I plan to explore where we stand on the when question, not narrowly in light of the current debate provoked by support, but instead as a product of the historical evolution of the prevailing ethical paradigm for research with human beings, which seems at times to be the result of a pendulum swinging from one pole to another. Let me suggest that we can understand this history by looking at 7 times when the ethical and then the legal paradigm shifted. Let me lay these out quickly, and then I'll elaborate on each one. So these 7 paradigm shifts begin with the period before 1900, where we had heroic physicians and the beginnings of scientific medicine. And then around 1900, there were some legal remedies that were created by the state and that were created by physicians. Obviously, in the period from 1932 to 1945, we moved into some very dark days, and then the reaction to that came at Nuremberg. In the period between 1947 and 1964, there was a retreat, I believe, from the Nuremberg ethics, and that was followed by another swing of the pendulum in the opposite direction in the following 12 years, with the recognition of those problems and further efforts at reform. The present era is one in which we have added complexity to the whole process of research ethics review and a culture of compliance. And that's led, during the past 10 years, to calls for the reassessment and a new ethics that I want to address. So let's begin then looking at the way this could be described. And I'm going to put this up quickly and come back to it. And in doing this, I want to make clear that what I have here is something that has to be understood as kind of a metaphorical representation. It's not an empirical representation, but it is intended to indicate the rising and falling level of ethics over the period that I've just described. And then we have a question mark where we're going today. So let's look at the first paradigm. The core question for 19th century physicians who aspired to be scientists was how they could become researchers and still remain true to the Hippocratic injunction, primum non nocere. Perhaps this is the first of the shibboleths that Norm attacked yesterday, though I believe it is possible to do both. In any case, in his great work published in 1865, An Introduction to the Study of Experimental Medicine, the renowned French physician-scientist Claude Bernard echoed the earlier injunctions of Immanuel Kant and Moses Maimonides in counseling his fellow physicians not to treat their patients solely as means of advancing knowledge. He did not suggest, however, that the subject's informed consent be obtained. Yet he did argue that physicians must always keep the welfare of patients foremost when conducting research. Around the turn of the 20th century, several events brought that medically focused paradigm where it was doctors taking the heroic step, taking the risks, on behalf of patients into their own hands. And that era came something to an end. And it began with the research carried out by Albert Neisser, the famous Prussian physician who had discovered the bacterium responsible for gonorrhea, when he inoculated in 1890 15 women and girls, one as young as 10 years old, with a cell-free serum from patients with syphilis. His hope and intention was that they would be vaccinated against the disease. None of those to whom he put these injections knew what the experiment was about. Many became infected with the disease, which at the time did not have a cure. The public outrage, once these injections became known, his work became known, led to both moral censure of him and a criminal fine. And 10 years later, in 1900, to a directive issued by the Prussian Minister for Religious, Educational, and Medical Affairs, an interesting combination, requiring that the possible negative consequences of each experiment be examined and that unambiguous consent be obtained from all subjects. Notably, this meant that no research could be conducted in orphanages. Also in 1900, Dr. Walter Reed was leading a team of U.S. Army physicians conducting research on yellow fever in Cuba, which had recently been taken from Spain in the Spanish-American War. A number of Reed's colleagues allowed themselves to be bitten by mosquitoes. When two of these Army doctors became infected, and one of them, Dr. Jesse Lazier, died, the investigators decided to switch to enlisted men and Spanish laborers. Reed was very aware of the charge leveled by William Osler that the yellow fever experiments done several years before by Santarelli on 5 immigrants in Uruguay were criminal because the subject's consent had not been obtained. Therefore, Reed developed a written consent form. It identified study risks, principally that the participants may develop yellow fever, but also placed those risks within the local context, namely that they were very likely to get yellow fever anyway. The loss of life during the Spanish-American War was principally due to disease, both among the Americans and the Cubans and the Spaniards. The contract also promised that if they did get infected, they would benefit from the care that the researchers could provide, which would be superior to any medical treatment they would otherwise obtain, particularly the Spanish laborers. The form promised the laborers a payment of $500 in gold, which would be doubled for those who developed yellow fever. And this was, of course, a very large sum at that time. Thus, as of 1900, with this second swing of the pendulum, the answer to the when question was that research is acceptable when legal requirements, either set forth by the government in legislation and regulations or in contracts that imposed obligations on the researchers and required the subject's consent, had been met, and in particular, when competent persons knowingly agree to participate. The frailty of this paradigm became apparent in the horrors of the Nazi concentration camps that were so vividly described yesterday. For the Nazi researchers and their Japanese counterparts studying diseases, seeking medical information for use in their war efforts, and at least in the notorious Japanese Unit 731 in Pingfang, China, also testing chemical and biological weapons. The answer to the when question was when it serves the interests of the state. What we most remember from those dark days, however, was the reaction, in ethical terms, in the articulation of what we know now as the Nuremberg Code. That was promulgated by the military tribunal as it passed judgment on the Nazi doctors in 1947. The 10 principles stated by the judges to explain when medical research with human beings is ethical began, of course, with one of those statements, the voluntary consent of the human subject is absolutely essential, that Norman Foss told us yesterday can't be right because we couldn't have biobank research or research on patients receiving emergency care or research on children if that statement were true. In some ways, the Nuremberg Code marked a high point in the development of research ethics. But as later became apparent, even as the American judges were pronouncing it, American researchers were carrying out studies that fell far short of the Code's commandments, such as the wartime research in U.S. prisons, and most particularly the Tuskegee syphilis study carried out by the Public Health Service beginning prior to the war in 1932 and carried out for 40 years until it was splashed on the front pages of newspapers by an investigative journalist. As with the second paradigm, the Nuremberg Code had neither a pervasive nor a truly lasting effect on the conduct of research for several reasons. First, the post-war period produced triumphalism in medical research, with the public and its representatives in awe of the new antibiotics, vaccines, and medical technologies that seemed on the brink of conquering disease, just as Imperial Japan and the Third Reich had been conquered. During this period, besides such things as STD experiments, not just in Tuskegee but Guatemala, boldly carried out by the government's physician scientists, even if not openly reported at that time, and the rapid growth of investigator-initiated studies, the archetype of the new science was the development of the randomized clinical trial, beginning with the trial of streptomycin for pulmonary tuberculosis in Britain, conducted, of course, without the knowledge of the patients enrolled. During this period, the when question was answered not only by saying that some patients could become the means of developing knowledge when physicians felt that a research goal was important and could feasibly be achieved, but also when national needs dictated. Many activities, not just the testing of atomic weapons, but also medical research on civilians, such as the ionizing radiation and LSD and related experiments, rested on this Cold War rationale. Equally significant, the World Medical Association promulgated the Declaration of Helsinki in 1964. This document is usually described as establishing high ethical standards, indeed standards so daunting that they have to be torn down as mere shibboleths by the critics. While I certainly share the view of many that the Declaration has never been a completely coherent document or one that can easily be followed, given its inconsistencies, what is most important, in my view, to remember about the Declaration of Helsinki is that it amounted to a major retreat from the Nuremberg Code. Organized medicine, particularly the German Medical Association, seeking to rid itself of the Nazi taint, wanted no part of a set of principles developed by judges in the concentration camp context. Instead, with the Declaration, organized medicine took back authority to set ethical principles for human research. The drafters of Helsinki drew a sharp distinction between research combined with medical care and research on normal volunteers. And as to the former, they continued the existing paternalistic view that physicians should tell patients enrolled in research only as much as they, the physicians, thought it would be good for them to know. That era of the retreat from ethics began to come to an end in 1966 with a shift from the fourth to the fifth paradigm, which continued to develop over the next dozen years. And there were two events in 1966 that really marked that as a watershed year. The second one, actually, chronologically, but the one which has always gotten the most attention, is Henry Beecher's publication in the New England Journal of his article, Ethics in Clinical Research, in which he recounted in detail 22 experiments which he regarded as unethical, principally because of excessive risk or because there was not consent from the subjects or knowledge of the subjects of the fact that they were in a research experiment, or both. And these 22 were drawn from what he said was a longer list of 50 examples that had been provided to the editors. Earlier in the year, Surgeon General Stewart required that public health service researchers, physicians carrying out research who were employed in the public health service, would have to have prior review. And that prior review was initially from colleagues. It was peer review, but within a short period of time, non-scientists were added to the process. And then, of course, eventually that was expanded outside the walls of the public health service to public health service funded research. 6 years later, the Tuskegee syphilis study was revealed, and a process began in the United States Congress with looking at that study and other examples from the 1960s onward of research that raised ethical questions. The Senate hearings were held very prominently the following year in '73, and in 1974, Congress passed the National Research Act, which incorporated the provisions which had once been intended as a separate freestanding bill, creating the National Commission for the Protection of Human Subjects of Biomedical and Behavioral Research. And besides creating that commission, the law required every institution receiving federal support to set up what it called an institutional review board. That's the origin of the term IRB, and required that there be consent of subjects. As a result of that commission's work, a number of reports on specific areas of research were published, and that culminated in their response to the charge that they were given to state the ethical principles underlying ethical research. And that was the Belmont Report, named after the conference center in Maryland, Belmont House, called Ethical Principles and Guidelines for the Protection of Human Subjects of Research. We all know the 3 principles articulated there and later expanded to 4 by Tom Beecham, one of the staff members with principal responsibility for writing that report. The principles of beneficence, and now beneficence and non-maleficence, respect for persons, and justice, and an explanation of the distinction between research and the routine practice of medicine, something that the Commission was also asked by the Congress to explain. When we think about the need for the Commission to address that, we should keep in mind that the federal government regulates research that it sponsors, but it doesn't regulate the practice of medicine. And so that distinction, which some people have suggested has a philosophical basis, doesn't have a philosophical basis. It's a jurisdictional basis. Congress, in the process of writing the statute and then the Commission in responding to it, was well aware that organized medicine in the United States did not want to be regulated by the federal government. This is an era where doctors were very sensitive to that. It was the first decade of Medicare and Medicaid, and there was already a lot of concern about the extent to which payment regulations would amount to ways of regulating medical practice, and this was going to be a sharp line. The ordinary practice, the routine practice of medicine was on one side, and only things which qualified as research. So we had to have the now famous definition of research to separate those two. Now, many people would probably say that that paradigm continues through the present. After all, do we still not turn toward Belmont and bow when we recite our bioethical prayers on a daily basis? Yet I think that in 1978, there was actually another change. This involved the creation of the President's Commission for the Study of Ethical Problems in Medicine and Biomedical Behavioral Research, the successor to the National Commission. It also involved thereafter the first response from the Department of Health and Human Services to the report of the National Commission, which was the creation of the basically the present format of the regulations in 45 CFR Part 46. And in 1981, the President's Commission, which actually didn't start in '78, didn't start until 1980, issued the first of the 2 biennial reports it was supposed to write on research regulation. And in that report, it urged that all government-supported research be governed by a single set of rules. There were then some, we identified, I was the director of that commission, so I say we identified 20-some different departments and agencies that had rules, recognized that most of the differences, as far as could be told, between the rules were wording differences. They were not in-principle differences. But if you're a conscientious IRB and research comes before you and you're used to looking at HHS research and this is going to the Department of Defense or the Department of Education or the Department of Justice and on and on and on, you wondered, are we doing the right thing in reviewing it? And if it wasn't clear where a research proposal might end up getting its funding, the same set of questions arose. And so we said, we should have a single set of rules. I guess it's one of those be careful what you wish for moments. And indeed, a couple of years later, there were additional protections for human subjects were issued as an additional part of the federal rules, and the Federal Advisory Committee on Science and Technology created an interagency human subjects coordinating committee, which was chaired by Charlie McCarthy, the director of OPRR, the predecessor of OHRP. And it engaged in a process which took it a mere 8 years, 10 years from the recommendation from the commission, but 8 years from the establishment of that committee to come up with the common rule. And one of the concerns that we've all had ever since then is, could we ever get the common rule changed to reflect experience and new thinking or whatever? And the answer from the federal government has been, are you crazy? It took us 8 years to put this together. How could we possibly do that again? And as we all know, it is now, I guess, 3 years since it looked as though something 20 years after the fact might actually be happening with the advance notice of the proposed rulemaking. And it's taken 3 years, and we haven't yet seen a notice of proposed rulemaking, so that skepticism about the ability to revise the common rule may be well taken. And then the Advisory Committee on Human Radiation issued its report, which led to the creation in 1995 of the National Bioethics Advisory Commission. And again, that commission argued that it was important to have independence between the body overseeing research and the funders of research. And on that commission's recommendation, OPRR became OHRP and was moved to the Office of the Assistant Secretary for Health. Again, not entirely clear how that is playing out. Now, what that I think has meant is that we have an increasingly complex and compliance-oriented world of research oversight. And that could go on forever. But there has been, as I've suggested, a current call for reexamination. And so that's where we are now. That existing sixth paradigm is now potentially up for revision, and not just through the notice of proposed rulemaking. So this brings us really to the heart of what I want to do today, which is to ask, for example, what constitutes research? That's up for grabs. Obviously, when the OHRP sanctioned the Michigan Hospital Association and all of its participating hospitals for the Keystone Intensive Care Unit study, using the checklist approach to avoid central line infections, they got huge pushback. And the question, how can you call what amounts to a quality improvement project research? Not a resolved issue. OHRP was beaten up enough that they backed off as to that. But if you're working in this area, or you have people at your institution that are working in this area, you know how nervous people are that sanctions could still be issued. Further, the question that Nancy explored with you yesterday: what creates risk? Does randomization create risk? And what consent is needed? Is it consent to the underlying interventions, or are those part of a treatment relationship, and all the consent has to address is any added risks, if there are any, from being in a research comparison of existing medical practices? And then the general issue that Steve raised yesterday about continuous learning by studying the outcomes of ordinary treatment, the learning health systems. So those who today want to break and reform the prevailing paradigm would answer the question with which we began: when may a society, actively or by acquiescence, expose some of its members to harm in order to seek benefit for them, for others, or for society as a whole, by saying either what harm, there isn't any, or by saying when those who would do this are acting to prevent avoidable harm, or are acting for the benefit of all in a way that would not otherwise be achievable. And they would point especially to studies conducted within learning health systems as the archetype of the sort of research that is not only needed and justified, but that requires a change in the norms of research ethics and especially ethical review. And this then has led to an even more negative critique, and I am going to be quoting here from Simon Whitney, who had a provocative article that many of you from the pediatric field probably noticed a couple of years ago in Pediatrics, called the Pythons Embrace Clinical Research Regulation by IRBs, in which he claims that IRBs add nothing but expense. They save no lives, unlike researchers who do, that informed consent is expensive and pointless, especially in studies of existing practice in which interventions are routinely provided without specific consent in everyday practice. In other words, reasoning backwards from the failure to get consent in medical care to saying, why would we then burden researchers with this obligation? And consent, if required, will bias trial entry, and he points to the fact that in the support study, a larger number of African American parents declined to participate, meaning that the results of support are more applicable to white infants than to blacks, despite the latter group's higher mortality, and that this therefore violates the ethical principle of justice. And a more cutting criticism from Carol Heimer, which says the biggest ethical lapse in American regulation of human subjects is the death and suffering that has resulted from slowing the pace and altering the focus of research and squandering of research funds. So I want to take that as the challenge. That's the call for a reexamination. But I want to say that a reexamination could operate from exactly the opposite pole. And I want to take us back, if you would please, to the thinking of someone who was also, like Eva Kor, deeply affected by the Second World War and deeply reflective about its lessons, especially about the abuse of power and authority. What I'm going to draw from is something that many of you may be familiar with, which he spoke about in most detail in this contribution to a 1967 conference held by the American Academy of Arts and Sciences, which appeared as an issue of the journal Daedalus in 1968. And that is the article by Hans Jonas on philosophical reflections on experimenting with human subjects. Now, Jonas was not against biomedical research. Indeed, he accepted the usual ethical justifications for conducting research, that it's all right when risks are minimized, when there's informed consent, and a worthy objective. These were the views that came to be accepted post-1966. His further qualification, however, was unusual. He said that research was justified when all of the participants had identification with the goal of the research, And therefore, the best subjects were researchers themselves, either the researchers conducting that research or those who were colleagues, because they would be most identified with this goal of advancing knowledge. He recognized, however, that at some point in research on illnesses, patients have to be subjects because you have to be seeing what the effect of the intervention is on patients. And so he thought they should only be used for studies of their own disease because they would also have identification with the objective there. And he was reciting examples of and attacking the use of subjects who were simply hospitalized patients or otherwise under the control of physicians and used for research not connected, even when they had formally given consent. But in describing the obligations of patients and physicians towards research, he set some very stringent limits based on the following rationale. The destination of research, he wrote, is essentially melioristic. It does not serve the preservation of the existing good from which I profit myself and to which I am obligated. Unless the present state is intolerable, the melioristic goal is in a sense gratuitous, and this not only from the vantage point of the present. Our descendants have a right to be left an unplundered planet. They do not have a right to new miracle cures. And then he went further in this famous passage. If some of the implications of my reasonings are felt to work out toward a slower rate of progress, this should not cause too great dismay. Let us not forget that progress is an optional goal, not an unconditional commitment, and that its tempo in particular, compulsive as it may become, has nothing sacred about it. Let us also remember that a slower progress in the conquest of disease would not threaten society, grievous as it is to those who have to deplore that their particular disease has not yet conquered. But that society would indeed be threatened by the erosion of those moral values whose loss, possibly caused by too ruthless a pursuit of scientific progress, would make its most dazzling triumphs not worth having. Now, given the amount of research that was going on, as you recall, not yet revealed or widely known in the 1950s and 60s, his comments seem almost prophetic in describing the harm that was done then and that was only later acknowledged and for which apologies had to be issued by the government to the victims of the Tuskegee experiments, to the victims of the radiation experiments, to the victims of the mind drug experiments, and so forth. So the question is Jonas's view totally radical? And is it irrelevant? As researchers thought the Nuremberg Code was irrelevant to the research that they wanted to do during that very period, and which they did without consent. They regarded it as irrelevant. Certainly, it's a radical view. Progress is an optional goal. It sounds so radical that it is often treated as an extreme position, acceptable perhaps to be held by a philosopher, especially one who had witnessed the 20th century's barbarities so closely and thought about them so deeply, but not relevant as a guide to policy and practice. But that view is clearly wrong. Jonas's proposition is actually the prevailing view. And if a Rip Van Winkle investigator from pre-1966 era of medical triumphalism and professional autonomy were plopped down in the world of biomedical research today, he or she would certainly feel the same way. Do we not slow down progress, or at least individual steps that individual researchers believe would move us in that direction? Every time we insist that an investigator must formulate his or her research plans in a way that allow a range of issues which they regard as salient and perhaps insist on various changes to those plans, to say nothing of the delays and notifications caused by DSMBs, IBCs, IACUCs, escrow committees, and so forth. All of these make the drive to achieve biomedical progress in the prevention, diagnosis, and treatment of disease secondary to other goals, other considerations of what makes life good and society livable and just. Jonas is simply spelling out in a dramatic fashion the conceptual basis for the apparatus of ethical review that grew up in the past 50 years. If his statement sounds more radical, it is either because we have understood the review mechanisms in a more modest and practical fashion, as concrete responses to particular problems, Tuskegee, Willowbrook, tea room trade, Milgram, the Jewish Chronic Disease Hospital, ionizing radiation, embryonic stem cells, and so forth, or because we recognize and reject the implications of actually putting any field of science, even one that takes human beings as its material for research, into a lower place in the value hierarchy. So now let me combine this with a look at the other part of my topic, young patients. Research with children, I think, crystallizes the ethical dilemmas that I've just developed around the issues of research. How should decisions be made when potential research subjects are unable to consent for themselves? Is special research needed to create and refine appropriate treatment because this group constitute a distinct population, whether metabolically or developmentally or in other ways? And then the question, is their identity as a group sufficient to justify research on members to benefit the future whole? That's the when question again. Now, up until the 1970s, I think it was generally accepted in medicine, law, and ethics that children could not be research subjects except for their own benefit. And this was the view that we heard about briefly yesterday from Lainey Ross, articulated by Paul Ramsey in his famous book, The Patient as Person. The contrary view, however, began to emerge in the 1970s, and in particular, another religious figure, Richard McCormick of Georgetown, held that it was acceptable when necessary to advance the interests of children to conduct research, and that parental consent provides the necessary protection. And the rationale is that children who are consented to participate in research are in effect being guided in their moral development because they're being shown that it is right to act to help others. In 1978, the National Commission, in its report on, its Belmont report, said effective ways of treating childhood diseases and fostering healthy development are benefits that serve to justify research involving children, even when individual research subjects are not beneficiaries. They came down clearly on the side that this was a group, you should think of it as a group, and individual members of the group can be made instruments for benefiting the group. They took the McCormick view. And they said research also makes it possible to avoid the harm that may result from the applications of previously accepted routine practice that on closer investigation turn out to be dangerous. Well, that is precisely the justification now given for research on practice generally, for the learning health systems. And in its report on research involving children, the National Commission then spelled out how this should happen. First, conduct research on animals, then on adults, and then on older children. Equitable selection of subjects and minimization of risks. When those are fulfilled, that's acceptable. Then, in subpart D, HHS spelled out rules for research on children. Where there is minimal risk, research may be approved. If it's more than minimal risk, but not no prospect of direct benefit, you can still approve, as those of you who sit on IRBs and submit research proposals to IRBs know, if there's a minor increase over minimal risk, and if it yields vitally important knowledge. No one, I think, has ever yet defined what a minor increase is, but we all use the terms. And if there's a greater than minor increase, in other words, a greater than this thing that we don't know what it is, if it provides reasonable opportunity for generalizable knowledge and contains sound ethical principles. So I'm saying that just as we have gotten to the point of saying, do we really want these research rules? Is it time to re-examine them as to everyone? We've already seen that illustrated as to children. We have decided that the value of the research to the population justifies research without consent, even when it involves more than minimal risk. So let me end then with a set of 4 questions. The first one is, have the problems and scandals of the past created undue burdens on conducting research in the present? That is the criticism, that's the central criticism of those like Whitney who believe that we should not have IRBs on OHRP. Are the present calls to dispense with consent and review simply manifestations of a compulsive drive for progress, which is dangerous rather than sacred? Should our answers to the question, when may a society expose some of its members to harm in order to seek benefit for others and for society as a whole, which is the hard part of the question, be different today than at Nuremberg or than in the Belmont Report? And finally, when consent is impossible, as for children, do we need a new explicit discussion of Hans Jonas's challenge to us, that research is an optional goal, not obligatory? And so as we look at that chart and look at the low points of the pre-1900 experiments and the World War II experiments, and the higher points when the law began to come in and when Nuremberg existed, although there was some retreat from it, and then Beecher and the Belmont Report, down to what has seemed to me to be the compromises brought about by the Common Rule and its application. We have to ask then, where are we headed? Are we headed to a new social contract where we will explicitly identify that certain kinds of research can be conducted when they are approved in a certain fashion without consent, and we are all in agreement that that's a social contract that makes sense? It has enough payoff and involves, with appropriate review, enough risk that we put consent aside and have a social mechanism? We do that in public health. This is not a radical suggestion. Or do we go back to the world of individual physician or institutional discretion, relying on the good intentions of those who conduct the research? That, to me, is the question as we enter the period of the 7th paradigm. Thank you all very much.